Lordship, I beg to mention item number 9.
Mm.
Item number 9. This matter will be released in the last week of August.
Last week or August?
Last week,
Item number 9.
7.
7th.
Yes.
Okay. You're on the other side.
Yes.
Last week of August,
Item number 7, no?
7. I'm for the estate respondent. 1 to 3.
Respondent number?
1 to 3.
Learned Senior Advocate Mr. T. Masa is present for the
Yes.
petitioners.
Yes.
Private respondent,
I am for the estate
state learned senior, learned
double AG.
the learned double AG.
DM song.
Respondent 1 to 3.
Is present for respondent number 1, 2, and 3. And
For 5.
learned counsel Miss,
Prohibitions for respondent 5.
sorry,
Prohibitions for 5.
is present for respondent number 5.
Five.
Anybody else? The learned, the double AG has prayed for adjournment. List this matter, after 2 weeks, 2 weeks?
Let it be last week of.
List this
Last
matter
week
on
of
the last week of August. All right.
Lordship, I have a similar appeal, item number 53. Hearing up in 53. Lordship, here I'm the respondent. I have taken the consent of the appellant. So this matter will be released after 2 weeks.
53, no?
53.
After 2 weeks.
After
Learned additional AG Miss,
MTM song.
is present for, the state
State respondents.
respondents. Only state respondents. Is
Yes.
present for the state of, Nagaland. And has prayed for adjournment, with the consent of the other side.
Lordship,
List this matter on
2 weeks.
after 2 weeks. Okay.
Lordship, I have some similar prayer. Item number 26, 27, 28, 29, and 30. Hearing item.
26 continuously. till
Yeah,
30.
26 to 30. Lordship, here I have an instruction from the state respondent that we will be allowed to grant 8 weeks.
8 weeks.
Lordship,
Any objection from your side? 8 weeks, 1.5 month, huh? Huh? For almost 1 or 2 months. You have objection?
No.
No objection, all right.
My lady,
26 to,
30. Item number 26 to 30.
my lady, in item 29 and 30, there's an interim.
okay, 29 and 30.
Interim, maybe continued.
Okay, you write down the names and then adjournment, then names of both the sides, huh? And only in 29 and 30 separately. 29 and 30, you continue with the interim order. You'll be able to type, no? Without dictation? Okay. All right.
May please, Your Lordships. Lordships, I beg to mention hearing item number 50 and 51.
Hmm.
Yeah, I'm appearing for respondent number 1. My lords, this is a consensus prayer. Since the matter will probably not reach today, so if these matters can come up after 2 weeks, I have
50
to.
and 51?
Lordship, this matter cannot be taken up by normal cases while longer. Right? So let it be before appropriate bench.
Okay, okay. She cannot take the, so
Yes.
next week she'll be here.
Yes.
So then after another
After, I
bench.
think
After, it will be better after,
let it be after appropriate, in the appropriate bench, after a week.
after 2 weeks will be
After
better
2
because after 2 weeks, Justice Robin Pukan will be here.
Yes.
So after 2 weeks.
Okay.
Yes. Learned Senior Advocate Mr. T. Masa is present for the petitioners and learned counsel Miss, your name?
Miss Lucino for respondent number 1.
Lucino is present for respondent number 1 and has prayed for adjournment. Anybody else?
Yes.
List this matter after 2 weeks.
Lordship. Lady, I also beg to mention item number 25 in the orders column, my lady. My lords, here, there is a similar matter which was filed together with this writ appeal, IA number 147 of 2026 in WA 32 of 2026. So I'm praying for these two matters to be clubbed together and list next week, my lead.
Okay. Learned Counsel, Miss
Miss Lucino, for the
Lucimo, no?
Lucino, my
Lucimo is present for whom?
the appellant, my
For the appellant?
yes, my lord.
Okay, okay. IA.
IA also,
Yes,
yes.
somebody else is present,
yes.
okay.
No,
Lucimo-
IA also I'm for the applicant, and
Okay.
in the writ appeal, I'm for the appellant.
Lucimo is present for the appellant. Learned AAG Miss A. Sukri is present for the state of Nagaland.
Yes.
Gustav D. Learned Counsel for the petitioner has prayed for adjournment. List this matter along with
IA 147 of 2026 in WA 32 of 2026.
on
To list it next week, my lady.
on the next week.
Obliged.
May I please,
After on the next week, you write a list is after 1 week.
Miss, please, your lordship, I bet to mention item number 40 to 43.
40.
40 to 43. This is analogous with item number 31 to 45. But I'm appearing in item number 40 to 43.
40, 41, 42, 43.
Yes, yes, I'm in this case
40, 41, 42,
43.
43.
Yes.
Okay.
My lady, on the last occasion, this court has directed to list this matter after the disposal of the review petition.
Okay.
So that petition is still pending. So I pray that this matter may be listed after
It's up to you.
after the disposal of the review petition. Yes, yes.
After 3 weeks or 4 weeks, I think it will be
After
better.
the disposal, that would, I think that would.
Our to go on. Oh, তেনেকে দি দিলে যাবগে তেনেকে দি দিলে যাব। So you see that other items tagged along with 31 till 39,
Yes,
if
this also should.
I pass the same order,
Yes,
it will affect these items also, no?
yes, yes. So it should be in item number 31 to 45 to be listed after the disposal of the review petition.
So we'll pass the order from entire article 30
Yes,
to
yes,
45.
yes, yes.
Okay.
But I'm in item number 40 to 43.
Your presence is only in item number.
Yeah, 40 to 43.
Learned Counsel, Mr. A. Santiangar, no?
Yes, Santiago.
Mr. Santiangar is present for the appellants.
Otherwise, my lords, if a date can be fixed without waiting for the outcome of the review petition.
No, already on the last occasion, this court has directed the matter to be listed after the review
lords, my
petition.
lords.
Yes, already there was a court order.
For the appellant and learned additional AG, Ms. V. Supri is present for the state of Nagaland, whose it is submitted by the learned AAG that an order has already been passed to list these matters after the disposal of WA number.
Review petition number
Review
11 of
petition number 11 of
2025.
2025.
Yes.
Full stop. Accordingly, list this matter after disposal of review petition number 11 of 2025. So who are present for from 31 to 39?
My lord, I'm for a respondent in respondent number, item number 31 to 39.
39.
Yes.
Respondent.
For respondent, yes.
Okay, okay. And petitioner is Santiago only. Who is the petitioner here? 31 to 39.
Appellant
Oh, you are the appellant, sorry. Not
item number
petitioner, appellant.
44 and 45.
You are the appellant.
Appellant is the state,
state
from
is-
item 31 to 39.
State is the appellant.
31 to 39.
Yes, 40, 41, 42, and 43 also, the state is still appealant. I am the respondent.
Okay.
They are challenging the.
Okay, okay.
decision.
Okay, state is the appellant, okay. You are the respondent. Oh. So, I got mixed up with the alienation. So you have to write in the other, or you have to interchange. V. Sukri is for appellant, not petitioner. Santiago is for
For the respondent.
respondent. So I'm looking at you and then I'm thinking about Guwahati High Court. Learned government
L-
advocate,
L likha se sanctum.
L Likha,
Se sanctum.
Likha se sanctum, government advocate, na?
No, for
No.
respondent.
You're
So,
for the
private
respondent.
respondent.
Oh. Just strike this out, just strike it off. From 31 to 39, learned
Government advocate E Thipa
Okay.
Pom. Senior government
advocate E Thipa
Pom.
form is present for the appellants and learned counsel, Mr. Your name?
L likha se sanctum for the private respondent.
L Likhase Sanctum is present for the private respondents. List this matter, then the earlier order. An order has been passed by this court, dated, which is the date?
Last 17/6/2020.
An order has been passed by this court dated 17
6/2026.
to list this matter after after review petition, after disposal of review petition number 11 of 2025. List these matters after disposal of review petition 11 of 2025. All right.
Lordships, I beg to mention item 3. If the matter can be kindly fixed on 9th of September for admission hearing.
For
Today-
admission.
Yes, for admission hearing on 9th
Learned
of
counsel
September.
Mr. Santiago has prayed for adjournment. Learned counsel Mr. P. Forte is present for the respondent.
Four.
List this matter
9/9,
Nine-
on 9/9/2026 for hearing on admission.
admission hearing, my lord. Let the interim be extended to the
Interim
next.
order shall remain in force till the next date of listing.
Deeply obliged, ma'am.
Please, Your Lordship, I may be allowed to mention item number 12 and 13, Your Lordship. Your Lordship, here, I've sent the affidavit for vetting, but the signature is awaited. So this matter may kindly be listed after a week. Item 12 and 13.
If I wasn't respondent for maybe we will like it. If I wasn't respondent for enough, he's talking about Item number?
12 and 13.
Nobody's got a petitioner here?
Your Lordship, I have informed the petitioner.
Okay,
So I've taken this
government
continuous.
advocate, Ms. Ina Holi, with the consent of the other side, has prayed for adjournment. List this matter.
Next week, Your Lordship.
After.
Prays for adjournment as,
After 2 weeks.
okay, as instructions are to be obtained,
Your Lordship, I have sent the affidavit
as
for
the
vetting.
affidavit has been sent
I'm
for
waiting
vetting.
for signature.
As the affidavit has been sent to the department for vetting
Lordship, after 1 week, Lordship.
after 1 week.
Yes, Lordship.
List this,
My lord,
Lordship, this is regarding detention, Lordship. Regarding detention, Lordship.
regarding what?
Detention, Lordship. Habeas corpus, Lordship.
Okay, detention, all right. List
after the 2 week,
after 2 weeks,
yes.
but it is regarding detention, that is.
Yes,
why-
yes, madam. But I think the subject efficacy.
One week,
Detention
Lordship.
after 1 week, detention. List this matter after 1 week.
Oblige, Your Lordship.
Bless, Lordship.
May it please your lordships. Lordships, I beg to mention item 10 and 11. On the last occasion on 5/8/2026, the state respondents were allowed to file additional affidavit on the new grounds raised by the petitioner. And I've sent the affidavit for vetting for signature, but the competent authority is on leave. So I could not obtain the signature, hence filed the affidavit. So, however, I have the case records if the court wants to continue with the case. But I was not able to file the affidavit today.
You want to file the affidavit?
Yes, I was allowed to file additional affidavit, Your Lordship.
You file the additional affidavit. Item number 11,
10 and 11.
10, 11. Yes, your name?
Medovero, my lord.
Sorry?
Medovero.
Medovero, okay, learned counsel, Mr. Medovero is present for the petitioner and learned government advocate, Mr. M. Lom Kumar
Yes, Your Lordship.
is present for the state of Nagaland and has prayed for
My lord,
adjournment.
My presence maybe can.
Yes, yes, sure. As the affidavit supposed to be filed today is sent for
Signature.
additional affidavit or
Yes,
affidavit.
yes, additional
Okay.
affidavit.
Filed today has been sent for vetting. Full stop.
That annually, CGC Malad.
Learned Counsel, Mr.
That annually.
Z Inahuli,
That annually.
N Holy, Z N Holy is present, huh? Sorry?
CGSC.
Oh, sorry. CGSC, learner CGSC, Mr. Z N Holy
Yes.
is present for, is present. That will be sufficient. List this matter, when do you want?
Next week, Your Lordship,
After 1 week.
after 1 week.
Obliged,
Obliged.
my lord. May I please, Worship? Worship, I beg to mention item number 9, my lord.
9,
Yes. Worship, here I am for the respondent number 1 and 2, my lord.
respond number 1 and 2.
My lord. Worship, here the leading counsel is indisposed today, my lord. So if this matter can come up after 2 weeks, my lord.
Yeah, I'm for the appellate.
Learned additional AG is present for the
Appellants.
appellant, and learned counsel, Mr. Medovero, is present for respondent number 1 and 2 and has prayed for adjournment.
Yes, my lord.
List this matter after
2 weeks, my lord.
2 weeks.
Much obliged, Worship.
Please, Your Lordships. I may be allowed to mention item number 22.
22,
I have instruction to appear for the private respondent number 5.
okay?
Kindly grant me 3 weeks' time to file Bakalat Nama.
Wakalat nama, 3 weeks time. You are for the appellant?
I'm for the private respondent number 3.
Private
Number
respondent
5.
number 3,
Number 5.
5, private respondent number 5. Learned counsel, Mr. H. Him
Lord.
is present for the petitioner, and learned counsel, Miss
AIME for state respondents.
A.
IME.
AI. A.
IME.
IME.
AYEM.
Is government advocate
Yes, Your Lordship.
is present for the state respondents, and learned counsel, Miss
Manosheno.
is, I didn't get your name. So and so is present for the respondent number 5 and is prayed for 3 weeks time. 3 weeks time allow? Shall I allow 3 weeks time to file Wakalat nama? 3 weeks time to file Wakalat nama, list this matter after 3 weeks.
Obliged.
May I please, Your Lordships? Lordships, I beg to mention item number 52. Here I am for the appellant.
Hmm.
I pray this matter can be listed on 16th September, Lord.
Okay, 16 September, learned counsel, Mr. I. Amiri is present for the appellant. And learned counsel, Miss so and so is present for respondent number 1 and 2. 1 to 72. Okay, respondent number 1 to 72. Learned counsel, learned government advocate, Mr. N. Angami is present for the state of Nagaland.
Yes.
Who has prayed for adjournment? And adjournment has been sought for the sought by the appellants. List this matter after on 16/9. All right. Hmm.
As the counsel for the appellants is disposed,
All right. Learned counsel, Miss, on behalf of learned senior advocate, on behalf of learned counsel, so and so, representing the appellants, comma, with the consent of the other side, has prayed for adjournment. You want your names to be recorded? Likha. Please write down. Yes, please. The name? Please write down. Okay. I've given the date, no? After 1 week, 2 weeks, anything? I have list this matter after 2 weeks. 24. Your name? Learned counsel, Mr. Masilezo Rote is present. and has prayed for time to file additional affidavit as he has obtained instructions from his clients to file an additional affidavit. Learned Counsel, Mr. Izamir, W. Zamir is present for the respondent or respondents. Okay, list this matter after how many? List this matter after 1 week. 1 week.
Hearing item number 46.
46.
I believe this matter will be adjourned for 2 weeks.
2 weeks. Your name? Miss Toshi Jamir, with the consent of the other side, has prayed for adjournment. Learned PP Mr. K. Angami is present for the state of Nagaland. List this matter after 2 weeks. Yes. Your name? K. Learned Counsel Mr. So and so, on behalf of Learned Counsel Mr. B. U.S. prayed for adjournment. PP Mr. K. Angami is present for the state of Nagaland. List this matter after 4 weeks.
From the supplementary cause list for motion, item number 54.
May it please your lordship. It's a habeas corpus petition, my lord. At this stage, my lord, notice may go, my lord.
Okay.
It's a case under preventive detention of the NDPS case.
After item number 54.
54 and 55.
Learned Counsel Mr. N.J. Doctor is present through video conferencing. Notices to be issued to the respondents returnable on?
Well, can it be a week, my lord?
My lord, regarding the number 1. That's electrician, not the family.
Okay. Cost title?
Yes.
You'll have to change the cost title, I believe.
My lord, the parties are at page 4, my lord.
Respondent number 1, I think
CGSC, central government.
there's an error, I think. You'll have to change the cost title.
My lord, it's
The learned CGSC.
yes, my lord, it's a Union of India. Union of India, my lord.
When you hear it is submitted by the learned CGSC, cost title is not correct.
My lord, which cost title, my lord?
Respondent number 1.
Respondent number 1 is Union of India, represented by the Secretary to the Government of India, Ministry of Home, New Delhi.
It's the Ministry of Department of Revenue. No particular PID. Yeah.
I think so, he's correct. You'll have to change the cost title.
Then, my lord, your lordship may give me, my lord, 2 days time, my lord. By Friday, my lord, I'll try to correct it.
Instead of issue notice, you strike out the sentence issue notice. Learned Counsel Mr. N.J. Doctor is present for the petitioners through video conferencing and has prayed for 2 days time to amend the cost title of relating to respondent number 1. All right?
My lord.
All right. You want your presence to be recorded? We'll issue notice, then your presence will be recorded.
Yes.
The next item also same, my lord.
Same order.
Same order.
54, 55.
I'm obliged, my lord.
For admission, item number 1.
It runs to the order is 29-7. I'm filing the However, I have The last order is 29/7/26.
29/7/26,
Already.
last order. Cannot find a last order. I've got it, I think. Yes, I've got it.
Between the respondent number 5 and format appropriate, then we will try to put on record a minutes of the same movie to the only place for distinct and matter of the films. Then to the last pair. Please the matter of 12 days before which date the respondent will file the evidence or copies on a particular. On 15/7, this note that also given is worthy to the respondent number 5 to file reply affidavit in respect of the affidavit filed by the respondent number 6. Such affidavit is not on record with the respondent number 5 shall file the affidavit in reply to the affidavit filed by the respondent number 6, which so applies before the mistake. Now, on the last occasion, I am speaking this note that a meeting has been convened between the IRDA, the respondent number 4, FPG, and the respondent number 5. It was a virtual meeting. So in the affidavit which I am going to file in your also the day, although I have submitted a copy of it, document please take out page 5, 6, and 7. Document please take out page 7 first. 7.
Yes.
Let him find
Yeah. You filed a, you filed a copy and give them, file the affidavit and give them the copies. Okay?
That is not so much effective, but normally team working to the effect that the meeting which was denied. Last occasion what we did, the conduct of the meeting was denied by the respondent number 4. That no such meeting had taken place, and I was being impressed upon that I am misreading the code. So that's why I am filing this affidavit today, and I am pointing out that indeed there was a meeting taken place, and
It's all right, it's all right. You file the affidavit, then you give furnished copies, and then we'll take up the matter. How long will you take?
Sometime in next week, because the council is the local council will be filed. Yours will take it next week.
Next week.
That's what this is about.
Then the week after?
26.
26.
Holiday. sir.
You want a date? No? Okay, you suggest a date? 2nd September. Learned counsel appearing for the respondent number 5. Mr. A. Kakoti has submitted that an affidavit has been filed. That he will file an affidavit. That he will file an affidavit filed an affidavit in reply, no? Affidavit in compliance of the order dated 29/7/2026 during the course of the day. Your presence, you want your presence to be recorded? Learned counsel Miss M. Mujui is present for respondent number 4. And before that, learned counsel is present for the petitioner. First line, no? This will be the first line. So this is the last line. Learned counsel Miss so-and-so is present for respondent number 6. List this matter on 2nd September. During the affidavit is to be submitted during the course of the day.
Item number 2.
You can take back. You can this can be used as copies. Can you help me with that? So far away, the table. Yes. I cannot hear you.
Mr. Yangarwati. Mr. Yangarwati, you adjust your microphone.
Yes.
Very little percentage, mostly of homicide, and in the
Question of homicide. Domicile, okay.
And they have used the wrong information in the forms. This is how their as the application has to be rejected.
Page 14.
Yes. Let's I will see.
Page 14 of the page 13 of your appeal.
Yes.
Yes.
You have corrected the,
Yes, I have corrected. There's a topic note, a big note also. Also not been corrected. Let's start in that. Last week, let me use last week. Because of the medicine. So the judge ordered the accordance of the correct concept of state district data are in view of for the preparation of result and fixing of the statewide and for district wise or general area.
Page 13, you are reading page 13 of your
Yes.
of your appeal memo.
Okay.
Page 13 of appeal memo.
Okay.
Which paragraph?
Ground of appeal. The best page, well, it's not.
Grounds of appeal?
Page 12.
Yes, grounds of appeal.
Next page is.
Entire page you are reading?
On page 39.
Yes, please read.
See.
See, okay, see.
Yes. Because the learned judge overlooked the importance of correct research state / district data, okay, induced for the preparation of result and fixing that of state-wise and further district-wise or general area district. Order regarding districts and makes up military affected districts and raising of correct domicile districts / state. It's not clearly regulatory, but it is mandatory. To waive the or value the stipulated terms and conditions that was introduced the element of discrimination, arbitrariness, and unfairness, age of domicile data, and any stage of examination will not disturb and unsettle the recruitment process and other value exigencies to rise before the administrative is development. Whether the recruitment cycle will never be complete. If we have a comprehensive cascading effect leading to multiple litigation across the country. And if the imperial judgment is implemented and the candidates for the consumer is accepted, then such an act would be discriminatory, and this would have a comprehensive cascading effect. And as such, the imperial judgment and order headed 21/05/2024 is liable to set the same and watch.
what is the, no, no, what,
While filing the application, in the application, they have.
Mr. Yangarwati.
Any information given will be available.
Mr. Yangarwati?
Yes,
What is the issue involved? Why the writ petition was filed?
we have given wrong information in the affidavit.
Where, what are the facts?
I have to.
You need not to read. You tell us what are. Wow.
you just summarize.
You s-
They are from another domicile and they have filed a wrong affidavit for their position to procure employment.
Yes, what you put no, you have some application.
They are from which place?
I don't know.
Huh?
They are from Nagaland.
Which place?
Yes. Different states.
Difference.
Yes, different states. So in the form we have in different domiciles district.
Yes, yes.
Some of the
For which post?
When you go to
Yes.
Why the petitioners approach the court?
For the post of constable. They are from which states? From
Yes, yeah.
which different states?
We are from different district.
Uh,
Same state.
Same state, different district from same state. So they now they are working or there's a stay. They are working now as constables. Have they been appointed?
Mr. Yangarwati, you tell us the facts. What made the petitioners to approach this court? What relief they sought before the court? You have directly jumped into the grounds.
Then we come to page 5, there is a brief facts of the case.
Okay.
You tell us, you can tell us the facts.
Summarize, you can summarize.
Yes, already, brief facts of the case. So,
Okay, all right, all right.
page 5 of my,
Page 5.
yes. Let me read.
Hmm.
The brief facts of the case are that the respondents in the exam will avail are all PBDs in the prisons of the state of Nagaland in various districts. Pursuant to the equipment process, the NMRs, the post of GP or the in the CRBA, the respondent had offered such candidates. As per the advertisement issued by the staff selecting committee, right, so inviting online application for the post of constable DD in CRBA, amongst others. The selection based process was based on 4 stages, namely computer-based examination, physical examination test, and physical standard test, and medical examination. On being successful in all aspects, the respondents were offered appointment on 15 June 2021, where they had been recorded and were assigned duties. The respondents were also given 4 standards. However, right, the first interview communication to the before 2001 issued by the office of the DIG. The offer of appointment was cancelled on the ground that there was discrepancies in the district of homicide and the district of permanent residence. Subsequently, the order dated 31/2003 was passed on final cancellation. Obviously, the application C 76 of 2002 was filed, which was subsequently passed by the legislature judge in favor of respondents. It is further investigating that the staff services function of this document of the status in CABA in Central in Assam Background Examination 2000. Next question. The recruitment process of constable DD in the CRBL is unique in the following ways. What become the leadership clause 1, clause 2, it is important. It is important to note that in view of the importance of the requirement of accurate information regarding domicile state and domicile district, the online application form required the delegate to fill up information about domicile state and domicile district. Twice from 2 different top-down menus, which were independent of each other, and subsequently these 2 entries were compared by the system generally, and the entries were accepted by both, but it only one match perfectly, and this has been done so any possibilities of being accurate and missing. So, when the data was matched, it was found that the information given were not correct. Yeah, 2 sets.
Thereafter,
Yes, sir.
thereafter what happened?
Thereafter, they were given members of termination. This was sent to the police court.
What the single bench held?
Civil, sort of we switch the degree of.
So this that cancellation order, or that whatever it is called, this has been this was single bench. Which page is the cancellation order? This is the impugned order before the WPC, before the single bench.
Yes, hello.
Which page? So when this appeal was admitted, was there any stay?
No, sir.
No stay.
Uh,
So there.
This is for admission. Okay.
Okay.
It's for admission.
So we'll admit it and then fix it for hearing? We'll admit it and fix it for hearing?
This clearly, this was on the next step, Lordship, there, so when admission is concerned, your Lordship. Admission of real equity. This Honorable Court in the case of Sonora Bora versus Assam State and Muslim Board has held that admission of real equity is not a matter of right. And
Okay.
an appeal should be admitted. Board should admit that.
So, okay, then we will fix it for hearing on admission then.
Because today Mr. Yangarwati does not appear to be prepared. So let him come prepared. We'll fix it for admission.
No, because I was asking the page of that impugned order, he was looking to the pages, that is why. So you'll be prejudiced if I admit it today. I understand. He will be not prejudiced, but you will be prejudiced if I admit it today. Without hearing.
Here, the issue, the order, the responsibility of the first, 21st May, 2024. And for non-compliance, were filed on their application.
So they are working or
No,
they're okay?
for non-compliance, the government.
Contempt is pending because of this appeal.
Because more than 2 years.
Contempt petition is also pending. Okay, okay. Then definitely we will have to hear on admission. Contempt petition is not disposed of.
No.
Why don't you take up the contempt
Because of.
pendency of this appeal? All right. Okay.
And for 2 years, Central Government Council is not prepared.
And those poor people, already appointed people, that too from the same state, not from another state also.
And because of that, the problems arise.
We'll dismiss this appeal. We'll dismiss this appeal today.
In fact, your lordship, in similar matter, I SLP, civil SLP, just missing. Lordship, I will wait up for till by saying I will let this will be listed on Friday also. Meantime, I will best for today.
Now you come prepared next Wednesday.
Because we can fix a date only on a hearing day.
This appeal was not prepared by.
No, on a DB day, not hearing day, sorry, on a DB day. This is item number?
On the next day, maybe dismissed.
Why to wait for a week?
Then why wait till next day? Why is that?
Because we have DB only on next week. Maybe dismiss, yes. So fairly submitted, you see, fairly submitted. Learned CGC,
Yes.
Mr. Yarangwati is present and has prayed for adjournment. Learned Council, Mr. TB Jamil is present for the respondents. List this matter on next Wednesday. What is the date?
19.
In the admission column for hearing on admission positively without fail.
For admission, item number 4.
In the course of having this honorable court has directed to file an additional application. Explaining the delay of the proof in sending this. And for which logic will file an additional application. Stating in paragraph 3. Paragraph 3 of the IA of chip IA.
In paragraph 3 of the additional affidavit.
However, lordship, there is some inadvertent mistake on the part of the felon lordship. Instead of this matter relates to Nagaland lordship, Nagaland district. However, lordship, there is an inadvertent mistake on the part of the respondent appellant to lordship by putting the district as Kohima lordship instead of Nagaland lordship.
Okay.
That was an inadvertent mistake.
Okay.
However, delay has been explained lordship.
No, you see, you'll have to correct the cause list. Have you filed any application to correct the cause list?
No.
Address is to be correct.
Lordship, if lordship make a, if lordship allow them, I will make a silly correction.
My lord, I filed application for it. It gives that false statement. It is a question of something, 260 plus kilometer.
How many kilometers?
267 distance kilometer. It cannot be in it.
No, there is only one statement which says that.
No, I know, 267 kilometers, I think within 4-5 kilometers also sometimes the area changes. The names of the area changes. Maybe here in Nagaland, because the area is huge, maybe it will change after 20-30 kilometers. But
instead of Nagaland, I extended with the.
So as he has appeared, then we will take it up there. 200 kilometers.
Because of that, traffic rules.
No, big as well. Kohima, Kohima is not one.
That's why it's really.
So long as I said, 200 kilometers. Okay then. If he's present, then we'll take it up then.
No.
Okay. We rectification is not necessary, no?
No.
You.
can correct it with hand also. Because why? Because watching.
I think with hand, it won't be allowed, I think. Cost title, I think there's a notification, it won't be allowed.
Engineer, no. However, lordship, while filing my application lordship, I have inadvertently said, instead of it should be as Nagaland, I have stated in Kohima.
Where?
Lordship, paragraph 3, lordship is lordship, and kindly comes to page 3, paragraph 3.
Of your additional affidavit.
Fourth line.
It's not the cost title.
Fourth line.
It's not the cost title.
No.
Then it's okay.
Lord. So lordship, I have stated in more particularly in paragraph 3 of my additional affidavit, where I have stated that lordship, the executive engineer lordship. Lordship, the executive engineer Nagaland has forwarded the matter to the chief engineer. That is the chief engineer and the completed all the speech on 24/3/2025. So lordship, the order was so as a reminder, the order this honorable court has passed an order on 1/21/2025 lordship,
the matter was then forwarded by the executive engineer to the chief engineer also on 24/3/2025. And lordship, I have also.
So just a moment, I'll just ask only one question. You see, this Nokla Kohima falls under the Kohima only, under the jurisdiction of the executive engineer. No, 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 under the same executive engineer or different executive engineer? Different executive engineer. Okay.
Yes.
All right.
So they are saying that it's but however, that was the email. That's what I. Lordship. Lordship, the reason for the delay is due to the shortage of manpower.
I think you better correct it through an application.
No. Not a week's time. Within a week's time, maybe it's.
Item number given as little, DTP 49.
This is item number.
Item number
4.
4, okay. Learned Counsel Mr. V. Jimomi has prayed for adjournment to file an application for correction of inadvertent typographical error in the additional affidavit.
No.
Okay. List this matter after 1 week.
After what?
You want your presence to be recorded? Okay.
What?
For admission, item number 5 and 6.
My lord, we were to appear in this matter. And the counter affidavit was not filed in this matter. Many adjournments were taken in this matter. Now, I hope I'm audible, my lord.
Yes, yes.
Yeah. So we have substantially finalized the counter affidavit, which is being sent today or tomorrow to the department for approval and filing. That is one part of it. The main point here is that they have made an application to the government, giving their grievances as far as the various notifications in this are concerned. And it appears that the government has not responded to it. So one option would be whether this matter could be re-referred to the government for their whatever view they want to take. If that doesn't suit them, then we can go ahead. We'll file the affidavit maybe tomorrow or so after we have finalized most of it. Then it can be listed for arguments. That's entirely their choice, because the object of the petitioners also is to see that fake entries are not made so that the tribal balance is not unnecessarily disturbed. That is also the very objective of the state. There's no adversarial inference as far as both the parties in this are concerned. But once I file my objection, maybe we will go in accordance with law, and even going into the question of maintainability of a petition of this nature. That is a separate thing. So if they wish to because they are right that government ought to have at least given some type of reply, whatever it is, that was not responded. So if they feel it is okay, then within a reasonable time, the government can look into the matter and then respond to it, which can dilute many of these things in its right perspective. And otherwise, we will have to go into the merits of the petition, which is completely their choice. which will include the maintainability and other things. So we have finalized substantially the replies, more particularly the preliminary objections in this. And we have also taken note of those speaking off the record, that some of the inconsistencies which they have pointed out, which I have seen, no doubt. So maybe, if required, we could address those questions in the reply which the government may like to give from the department side. So it is their choice, my lord, that if it could be referred back, that is it. If they want it argued, then the affidavit is already being sent today. Then on receipt of that, a date can be fixed for arguments, whichever suits you, because it's not an adversarial thing, I have found out. Not that your petition lacks anything, or that's a separate thing. But I also felt that the government should respond to it. That would be in the fitness of things. And meanwhile, maybe if there is any inconsistency anywhere, we could also address it, because the matter is sensitive and it has got various ramifications, and we don't want to disturb the equilibrium as the first state is concerned. So I leave it to them whether that would be okay with them, or whether they would like to straight away get it fixed for arguments. That is, I think that would be entirely their choice, but this is my submission. I leave it to them and to the court.
Yes.
I know we have taken a lot of dates, no doubts about it. I've seen all those things. No issue.
Lordship, Lordship Mechanis is the last order passed on 22/7/2026.
Yes.
Lordship, last chance was given to the government to file. Lordship Mechanis see that the matter relates to, it's a very sensitive issue. Who is an indigenous inhabitant of Nagaland? That is the subject matter of the case. Lordship, in the year 1977, just a brief background for Lordship Corporation. In the after statehood, Lordship, the state government, not only indigenous inhabitants of the state of Nagaland are eligible for job employment, and immovable properties also to be given to only indigenous inhabitants of Nagaland. Now, the criteria who is an indigenous inhabitant of Nagaland was settled by notification issued on 28 April 1977 by the state government. Now, in that notification, this is part of the PIL part for easy reference. This is part of the PIL part for easy reference. Lordship, the three criteria is electoral rule. The three conditions are there. The cutoff is 1st December 1963. Model 1, 2, 3. This is the criteria to determine who is an indigenous inhabitant of Nagaland. Now, Lordship, to determine who is an indigenous inhabitant of Nagaland, Lordship, to issue the necessary certificates to be eligible. Lordship, the initial condition was that it should be verified by the concerned native villages in Nagaland, because Lordship, many villages have been established after 1963. In fact, our report shows that many village people from other parts of the state also have migrated to settle in Nagaland. After 63 villages have been established. That is the issue. Now, thereafter, to cut it short, then in the year 2016, this notification was superseded by the state government, unfortunately. But the same criteria was made applicable. If necessary, Lordship, I will show the necessary report. And what has happened is, though the notification of 77 was set aside and so proceeded in the year 2016, the three criteria was followed. Thereafter, Lordship, there was huge hue and cry from the different sections. It is like, Lordship, the sincerely foreigners issues of Assam. So, my lord, thereafter, the state government constituted a commission.
No, you are agreed with what?
I'm coming to that. Yes. Because
But you see, they are seeking time to file an affidavit.
And the affidavit is almost ready. We will send it. That is why I said we will do it, because we are not arguing it without the affidavit.
We don't want to take any time. The affidavit is complete from our side and will be sent to the department for approval. And they will file it maybe in the course of next week or so. Then you can fix a date, because I only said with good intentions that the matter may be looked into by the state. Then we can forget that, we can argue the matter. And we'll argue also on the maintainability of this PIL, which in law is not maintainable. So we will get our affidavit on record, and then it can be listed for arguments. Lordship, I'm not confronting the advocate general at the moment. I'm just narrating the facts because the case is listed before the Lordship for the first time. So your Lordship will be curious. That's why I'm giving the brief facts. Otherwise, Lordship, there is no.
No, you brief us.
Yes. So thereafter, Lordship, Register on Indigenous Individual of Nagaland Act Commission was constituted by the state government, and the state government examined the issues, having a consultation with all the stakeholders, all the tribal hosts, every political parties were called. There was a detailed consultation. Thereafter, the commission has recommended that since the criteria laid down in 1977, this 1963 criteria, the Green High Commission has recommended that 1963 criteria of 1977 should be followed. And since the 1977 notification has already been preceded by the government, Commission did not revive this, but the recommendation was that criteria, the three criteria laid down in 77 notification should be followed. One. Secondly, the Commission also reiterated and recommended that the native village, that is, the villages which was there, in the first election of 1964, only in that time there was only three districts, Tulisan, Mokokchung, and Kohima. So in the erstwhile, so the two districts of Tulisan and Mokokchung and Kohima, we held election for 40 assembly constituencies. And in view of Article 371A, a regional council was constituted that time. So there was no election in the remaining 26 in the year 1964 election. So the Green Commission has recommended that to determine who is an indigenous inhabitant. The native villages should be the villages which was included in the delimitation of constituencies for the 40 constituencies in 1964 election. And for the remaining 26, that is the villages that figured in the 1961 census. That should be the basis. And anybody who claims to be indigenous has to trace back to that native village, and the native village that particular village should certify that yes, his grandfathers or his forefathers fulfill the three criteria. On the basis of that recommendation only, the indigenous certificate should be issued. That was the recommendation. It was placed before the cabinet, and the cabinet approved the recommendation of the Green Commission in principle. Then the cabinet recommended to the Home Department that proposal for proper legislation to be framed and to be put up to the cabinet. Now, while doing that, the mischief came, and in the subsequent notification of the cabinet memorandum, what has happened is the word native village was changed and manipulated into recognized village. Now, hundreds of villages has been recognized after 1963 in Nagaland. So the criteria now is, if any recognized village give a certificate as he is an indigenous of that village, then indigenous certificate to be issued. For example, suppose, God forbid, but if tomorrow some Bangladeshi immigrants come to Nagaland and settle in an area and that village is recognized, God forbid, and if that village council, since it's a recognized village, issue the certificate, then that will be the business. That was the situation. And Lordship, in that cabinet memorandum, unfortunately, the 1963 criteria was removed, totally silent. And thereafter, Lordship, it was approved by the state government. Recognized village and the 1963 criteria is totally removed. And thereafter, the new modification, which we have challenged,
2016.
29/2024 to page 259 was issued. That is a situation.
254.
And your lordship, accordingly, lordship, this PIL was filed, lordship, you can see the order was on 18/3/2026. In fact, the question of maintainability, everything was heard that day. And lordship,
On which day?
my lord, when the notice, when the notice was issued on 18/3/2026.
On question of maintainability was
My
heard.
lord, lordship, you can see, notice was issued, and lordship, you can no.
Okay, 18/3/26, okay.
Yes, if lordship, you can read the order, that everything is mentioned in detail. My lord, this will be in WPC PIL number 3, not the first item, this will be in item.
Where is the impugn notification?
My lord, in item number 6, my lord, PIL, so I am getting in item number 6.
Item number 2 and 4.
Item number 5, sorry, item number 5.
4, I think.
Item number 5. PIL 2.
PIL 2, okay,
Yes, I
okay.
PIL 2.
Yes, yes.
Now, my lord, if you lordship, you can read the order passed on 18/3/2026.
That's a long order.
Yes, but then here, lordship, we can see that, lordship, we can see from paragraph 9.
No, but you see,
The
the
question is.
learned AG has submitted that
Coming to that.
on maintainability also, we may not hear.
I'm coming to that. And limited to this was issued. Lordship, we can see the last paragraph of the order.
18/3/26.
Yes, paragraph 11 onwards.
Yes.
Paragraph 11. In view of the Cabinet decision dated 11/9/2024, one notification and one order was issued on 2019/4. The notification bearing number 29/2024 specifically related to the 15 recognized tribes who are residents in the states. In terms of this notification, there is a requirement of a constitutional village verification committee in every recognized village. The village verification committee has to verify and attest the application form, which is annexure 1 to the notification dated 29/2024. The application form thereupon will be submitted to the area administrative officer along with requisite documents, proof of identity, and distance. The administrative officer shall then verify the applications as will the report contain genuine amount shall be forwarded to the commission. Model, prior to that, lordship, you can read paragraph. My lord, paragraph 16, please. In the backdrop, let us, paragraph 15 onwards, lordship. Paragraph 15, in the backdrop of, let us check the case of the petitioner who alleges that the Cabinet notification between 2024 and so far as it relates to Naga tribes. There is no mention as regards the cutoff to the effect that the candidates or his or her parents or their forefathers were inhabitants in the state of Nagaland prior to 1/12/1963. We have used the notification dated 29/2024, that is the Indian number. And we also therefore reveals that the notification is signed on the said aspect. We are tenacity of the opinion that the government of Nagaland have not incorporated the said aspect. As it is the cabinet that is decision that in so far as the 15 tribes coming under Naga tribe, it will be issued irrespective of their location. However, it will be in the interest of justice to obtain such clarification from the state. Under such circumstances, it is only on this limited extent we issue notice making it returnable on 24/2026. The respondents therefore herein more particularly the respondent number 1 and 2 shall bring a report by filing an affidavit as to whether the notification dated 29/2024 insofar as it relates to 15 other tribes would require a candidate to satisfy that his parents or forefathers would be citizens of the state of Nagaland prior to 1/12/1960. So on this limited issue, notice was issued. Well, now thereafter, my lord, because my lord, it is not an adversarial petition. I agree with the advocate, not that it is not adversarial in nature. It is for the benefit of everyone, and issue is so sensitive that unless it is handled carefully, my lord, it may explode.
It has to be handled
It is a
carefully.
very sensitive matter. So, my lord, what is happening is, thereafter, we were informed in the last round of hearings that the instruction were received. Accordingly, on 25/2026, last chance was given to the state government. Lordship, that is in the order of.
No, but it is submitted, no, they are undergoing the process.
I'm not, it is not admissible, but I'm just clearing the facts. On 25/2026, last chance was given to the government to file the affidavit. That is another call. Thereafter, on 17/6/2026, the matter was dismissed again. You prayed for second last chance. We did not object. Thereafter, my lord, on 22/7/2026, he asked for last final chance. So we objected. We objected then that that they are taking the case too long. So, my lord, we prayed on that day that if the affidavit is not filed by 27/2026, then we have prayer for interim. In item number 6, when there is a prayer for interim to stay the due order. So, my lord, the court passed an order that in the event the affidavit is not filed by 22/7/2026, interim to be considered. That was the order passed on the last occasion. Now that is the Advocate General is appearing, and he's talking about filing a full-fledged affidavit, but then the affidavit, the order of 16/3. 18/3 is notice was issued for a very limited purpose. Because, my lord, this one of the court also appreciate the sensitivity of the matter.
Yes.
If the state government take a stand, then yes, we still stand by the 1963 right cutoff. Then, my lord, there are rooms for everyone to come to an understanding after that. But then, my lord, unless nothing in black and white, the state government file an affidavit, what you should stand on the limited notice. I can't say we will accept this or that unless Nagaland lordship is become to this honorable court in terms of 16/3/2026, 18/3/2026. He filed an affidavit in black and white and answer to the queries of this honorable court. It's simple as that. Thereafter, lordship, if there is other issues, that would be subject to instruction. But then, my lord, in this stage, we will not go into all the other issues. But government should come with an affidavit on this only, on the order 18/3/2026. But then, lordship, since May. Last year, May, and then the matter is taking there. I don't know what is the reason.
You see, the learned AG has submitted that the affidavit, they are in the process of filing. They'll file today, is it? This is
No,
what
it is being sent today
sent
to
today.
Nagaland. In the course of the week, they would place it on record. And
In the process
in
of
fact,
filing.
we need not go in for any further
Yes. We'll
back
be
to the
fixing
government.
one date for affidavit.
Yes.
As they have sent the affidavit, fixed for affidavit.
Yes. So we will file the affidavit in the coming week. We'll file it. My statement can be recorded. And
Yes.
thereafter, a date can be fixed for arguments. We can straight away argue it. And the first argument will be on the maintainability. And after that, we can go into the merits. I'll do that. I only said in good faith that maybe this could be sorted out. But now I think we should go ahead with the arguments because they don't seem to be inclined.
Lordship, once the affidavit is filed, lordship, and if you, and then after we go to the affidavit, we will receive instructions and the case will progress thereafter. But currently, in terms of that.
No, but it is submitted. They have already sent the affidavit today. So we'll fix for affidavit. Yes. We'll fix for affidavit.
Lordships. Here I'm appearing for item number 6. If I may be able to submit.
Yes.
Lordship, is.
I can't see you.
Yeah, let's look. I'm here, Lordship.
Oh, okay. Okay.
They have also filed for the same course of action. We're challenging the same order. However, in our PRL, we have prayed for escape while endorsing the submission of my legal senior counsel. My other peers have prayed for escape of tribal council. September 2024. It's on page 178 of the petition for AO of law. So after bringing several times for them to file affidavit, this court, after taking into consideration for submission time and again, it's made very clear on 22/7/26 that if not filed within the next fixed date, the prayer for interim order should be considered. So my humble prayer is, if this prayer may be considered for today. Taking into consideration of the learned AG's submission, we, in the interest of justice, we can always.
No, you see,
The-
that AG has already submitted
Yes,
you
yes.
affidavit, they have sending, they have already sent the affidavit.
Please bear with me.
My interim
Please bear with me.
For the interest of justice, regardless of any submission, if one prayer may be considered for the.
Interim, you see, interim prayer will be like considering the entire case.
No, Lordship.
No,
just-
no, no. In fact, this is a fit case to be dismissed on maintainability itself.
Say
We'll
okay.
argue that point when it comes.
Not to take step in respect of this order, that's my humble prayer.
No,
Just for
no,
the time
no,
being.
because you see, AG has appeared and he has already submitted.
Yes, regardless of the age, yes.
Item number, which item number?
Item number 6.
PIL number
Two.
2,
Number 5.
PIL number 4.
Her submission is recorded. Her submission. is
We'll record your submission. We'll record your submission.
It may be considered.
We'll record your submission, but you see, I am very hesitant because while taking up the hearing on interim stay, everything will be considered. So what will be the point of hearing or admission at all?
It may not.
I understand.
And it will take time to find it.
I understand. Yeah, the order was passed, no doubt about it.
Even on the preliminary objections, I may
Sorry?
say so.
Sorry?
On the preliminary objections also, which we are going to raise in this petition, unfortunately may not be maintainable under PIL, even according to the Honorable Gauhati High Court rules.
PIL number 4 of 2025.
But like we see here.
There is a analogous matters.
Order dated, which is the last order dated you are referring to?
The same order.
18th.
22/7.
22/7.
Yeah, this matter is analogous of the order passed.
Okay, together,
Yes, common order.
common order was passed, okay. Order will record your submission, but very hesitant.
Now, whether government is issuing this indigenous inhabitant certificate now.
Lord, that is when I need to clarify it. In course of that, because Lordship, the issue is now even people who are not eligible, they have been randomly issued. That is how we are coming before the Honorable Court. We have been submitting representation all along. Since 20.
Once they are found to be continuously staying from 63, they will be issued a certificate.
Yes, so my lord, we have made prayer for verification of it, even it has been erroneously issued, because of those prayers are also there. But then in terms of the order dated 18/3, published file affidavit. It is for common good. We are not trying to find fault with anybody for to keep the large interest. We are only we have.
I understand.
Not to find fault with someone. There may be irregularities, but that is also subject to review and rectification. We have not approached the report to find fault with someone, but to find a common solution. But then, unless and until the stand is taken, because the issue has been tracked for so long. And a lot of unwanted element has come and manipulated the system. That is why we are apprehensive that unless we are finding orders of this honorable court, tomorrow we don't know what will happen.
Nothing will happen. I already made a statement that we are filing the counter affidavit. When I have made that statement, that is the statement. I am bound by that. We will send it to the department, they will peruse it, approve it, and they will file it. Thereafter, this matter can be listed straight away for argument on merits.
Yes. We must go through the affidavit.
And we believe so that there should be a time bound. And once the AG file it, the receipt instructions and accordingly will go ahead.
Okay. We'll record AG's submissions. Learned Senior Advocate Mr. T. Masai is present for the this is PIL 2, huh?
Yes.
Present for the petitioners. And Learned AG, Mr. K. N. Balagopal. Learned AG Nagaland, Mr. K. N. Balagopal is present. And Learned additional, your name also, okay. Learned additional AG, Mr. Imti Imsong is present.
The other names we have informed to him, madam. We'll give it to the court master who are appearing government advocate from Delhi.
Okay. Please record all the names, sir.
We'll get.
All the names, sir.
Please.
Please record all the names.
Yes, we have given it. to Mr.
Record the presence of all the council. The learned AG has submitted that an affidavit as per order dated 18/3, no?
Yes.
18/3/2026 has already been sent, which will be submitted before this court. Full stop. The issues raised have also been taken up, and the affidavit and through the affidavit, the issues will also be addressed. Okay.
Yes.
The learned
Also
senior-
the maintainability, my lord, the maintainability.
It is also submitted that this case may be fixed for argument primarily on the maintainability of this
Please.
petition, and
Please,
thereafter the merits can also be taken up.
Please, please.
And the merits of the case also can be taken up, full stop. The learned senior advocate has raised serious objections stating that although this issue is a sensational issue, several adjournments have been obtained by the state, which is procrastinating this case, full stop. The argument may be taken up today, full stop. I have considered the submissions at bar, as the affidavit is already under process, list this case for argument after submission. Not for argument, okay. All right. List this matter after 1 week.
Let us be sure that we file it after a week. I hope,
When I have made a statement, I don't think you need to have any doubt on that.
List this matter after 1 week for the submission of the affidavit positively, full stop. Okay, 1 week, and that you want a date?
Because the dates on that day.
Next Wednesday?
Give another date for arguments, which is convenient to us also.
I think for affidavit we'll fix next Wednesday.
Yes.
Only
And
for
on
affidavit.
on that date, you can fix the date for arguments.
Okay, yes.
Right.
So next Wednesday will be, next Wednesday. 19th. And the other case also? Same order, but the name is different. In place of, in PIL submission also same. In place of
19th date.
senior advocate Takamasa, you record the name of, your name?
19 August.
What is your name once more? Okay, yes. Got it. Alright.
Hello, bless.
For admission, item number 8.
Break it alone. We'll take a break. 5 minutes break.
Here, it's an issue with the VC, I think the next case is.
Okay, okay. Through VC. Yes, yes. Item number
14.
14.
14.
14, 15, 16, okay.
Yeah, no, we are for the appellant in this matter.
Not with the inverted image. John Curriculum.
Adjunct Curative. 14, 15, 16. Learned Counsel Ms. Clovey Sukru is present on behalf of CGSC B Decca. Representing the appellant, full stop. Learned Counsel Mr. T.B. Jabi is present for the respondent. An adjournment has been sought on behalf of the appellants. List this matter after?
Next week.
After 1 week. After 1 week. Break it a little bit, no? Both matters. So next week. Next week, खत्म हो जाए.
Regarding the item one,
Item number 1?
item 8.
88. Yes, yes. What do you want to say? Yes, it will go through the, okay, through the issue notice to the respondent number 2, item number 8, through the office of the PP routed through the registry of this court. Okay. একেবাৰে শেষ কৰিব পাৰি নেকি? Wait, finish it. We'll call you. Huh?
For orders, item number 17.
May I please, my lord?
We'll come after a break. 5 minutes break. We'll come after
All right.
5 break. Please call them. I see.
Five minutes break, yes.
Six.
Six of six, just six. Six. Is it 1, 2, 3, 4, 5, 6? That's all. Only the order problem. Actually, even that next we have the promotional class event, that is the although mahal na course na rin. Pas mo din dito dito di ba ko yun. Boleh na. So you can pass this to the
Yes,
May I be before, my lord?
yes, yes.
My lord, at the outset, my lord, subject to what my learned friend may suggest, my lord, I would, my lord, acknowledge the facts that, my lord, this petition, my lord, in fact, my lord, this court is kind enough, my lord, to grant all the relief, my lord, even before final adjudication of the matter, my lord.
Okay.
So, my lord, only now narrow canvas, my lord, which I will, my lord, highlight because of the fact, my lord, what is troubling me, my lord, here, though relief has been granted to me, but the wider aspects this court has required to consider, my lord, because of the fact that, my lord, possibly this is a situation where, because in Nagaland, my lord, this a person in conflict with law juvenile, my lord, such kind of cases are very rare, my lord, rarely registered. And because of that fact, my lord, maybe possibly this error has so occurred and those procedures that whatever provision has been incorporated under the Juvenile Justice Act and the rules 15 that has not been fully adhered. So, my lord, just as to if this court inclined, my lord, while, my lord, considering this writ petition, my lord, some streamline has to be, my lord, if made, my lord, in the features to come, my lord, such kind of casualties, my lord, I must with due respect, my lord, say that would not be repeated, my lord. Because here in this case, a person
So
below 18 years,
you were declared a juvenile?
my lord, yes, the report is here, my lord. We have received, pursuant to the order passed by this court on earlier occasion, we have received a report, my lord. And the report is here, my lord, on part of record. Report has, my lord, now has came saying that the person, juvenile person is a petitioner son is who is a juvenile is he's declared to be a juvenile, my lord, by the learned JJB, my lord, as I have seen, my lord.
Then what is there to be done? This case has become infructuous.
This that's what I the outset I have submitted, my lord. The only thing now is the court has to see, my lord, that whether if court declined to accept the report, then I may be declared as a juvenile in conflict with law as has been sought by me. And whatever, my lord,
Where is the report?
petition,
Where is the report?
report is on, my lord, there, part of record. Last date, my lord, report was there, my lord.
Records are before this court.
Yes. Now,
Order dated, my lord, 24/6/26, my lord.
466.
4/6/26, my lord, last paragraph, my lord. After they have conducted
Seal cover thing.
inquiry in pursuant to this court order, my lord, now they have found that the petitioner was, the son was to be juvenile on the date of alleged offense, my lord.
Transfer of care to be postponed. Submission of report in compliance with 3626. Report to nine. Gauhati disseminate. Proceeding with proceeding to us.
You have any submissions?
Yes, yes, I think this is much as now.
Hmm.
And so we view is the child and the child request child profiting law. So the matter may also be functions and we demand it back to the letter to the Juvenile Justice Board in terms of section 15 of the JJ Act, where the board will assess, really make assessment of the each purpose because he's of again 16 years old.
16 to 18.
Yes, here the child will complete before this was 7 years as on the day of the original the act. So the letter will be amended back before six letters with the section 15, 18, 18 and 19. If 15 then 18 then we don't need to prepare.
Yes. To go above proceeding. Do you have the report?
Yes.
So the report was sent to us also, but I cannot find it in the record. Okay.
When the reporting release. Report which has been sent.
You want to go through the report? This one. Like, it's a lot of- Cannot find it. Yes, please find it. Cannot find the report. Report dated given as 27 given date to sub. 12/6/26. I cannot find it. Thank you so much.
And to be below it.
Mm. Accordingly, based on the grounds mentioned, this bodies of the was a juvenile and Mubarak Ali. Okay. You are for the petitioner Mubarak Ali.
Yes, my lord.
Mother is here with us. Mother of the child will be. Those mother.
Mother is here. Okay. Dictation to DD. I'll start with the, I am dictating the order. If anything has to be inserted in the order, please, please inform me, okay? You just inform me, interfere and inform me.
My lord, just one thing, I just.
And details so much.
Move faster, move faster.
3625. And details so much.
Oh, they don't বেশি পছন্দ করি। This is good. 36/25 না?
25.
Oh, it move.
The facts in the person. ಒಂದೊಂದು ಬೇರೆ
Delhi also. Third learned counsel, Mr. N.K.
Just one, my lord, just one thing I'll just like to indicate, my lord.
Sorry?
This issue, my lord, just one thing I'd like just to indicate, my lord.
Yes.
This issue also, on the other hand, my lord, has been brought up, my lord, when the IO of this case has projected that there is a conflicting Aadhaar card, two Aadhaar card. One Aadhaar card has to be seized by the IO.
No, we'll not take up all this now. This matter has become infructuous.
No, my lord.
Go before the JJB.
No, I'm not saying that, my lord. Lord, that is what, my lord. Just 1 minute, my lord. With lordship. Indicating that the
Not
juvenile.
1 minute, less than 1 minute.
No, just one thing, my lord. Just indicating that the juvenile was possessing Aadhaar card, which shows he is a major. For that reason, I was detained in jail. And as per the government notification, central government notification, and the consideration bench judgment, my lord, as your lordship is aware, Aadhaar card cannot be used as a proof of age.
No,
But sir, it cannot be. And my lord,
Not
now.
take up all this now.
No, my lord, this court has, my lord, may kindly accept a report saying that, my lord, the person is already a juvenile, my lord. That may be declared, and my lord, whatever detention, my lord, I was in custody, jail custody, my lord, that has to be declared illegal. That much, my lord. Otherwise, my lord, this court.
A juvenile. We don't have to declare you a juvenile in writ petition. We have already.
My lord, because of that, lordship may accept a report, and my lord, my detention has to be declared, my lord. My detention has to be declared illegal, my lord. Otherwise, lordship is quite aware, my lord. This court, honorable court, being court of equity, has a power to mold, my lord, has jurisdiction to mold even the relief sought for. But I'm not bringing for any compensation here, my lord.
Okay, it's
And
okay. Just
my
a
lord, it remind me one thing, my lord. Justice should not be only be done, but manifestly should be done, my lord. That what remind me, my lord. That's my lord, it's a settled proposition, my lord.
No, I want to mute ourselves.
At this stage, I'm not praying for any compensation, my lord, for illegal custody, my lord. All I'm saying is, my lord, my detention should be declared illegal. That much, my lord.
As he has been already declared as juvenile, we accept the
The rules, the juvenile provisions of the Juvenile Justice Act, my lord, and the rules does not provide the person, a juvenile, to be sent to jail, my lord. Cannot be put in jail or in police custody. That's what the rule mandatorily provides, my lord. It's a mandatory provision. Now you have held me for, my lord, month together in the jail, and you fail to even enlarge me on statutory provision. And my lord, even before Jarshid also enlarging on bail also, continuously I am appearing before the learned court below, my lord. On what ground, my lord? Even with during investigation also, my lord, after my enlargement, continuously I am appearing before the court below, my lord. So such kind of, my lord,
Just a
practice has to
moment.
be looked into, my lord.
Just a moment. You see, you are above 16, below 18.
Yes, my lord.
You can be also tried as an adult
I'm not saying that, my lord.
in heinous offense.
I'm not saying that, my lord. That's what, my lord.
You are
In such
already
a case, my
granted,
lord,
you see, you are already granted bail by
yes,
this court.
by this court. Now my detention has to be declared, my lord, illegal. That's all, my lord. Otherwise, my lord, what lordship just indicate has correctly indicate, my lord. This is a recent judgment, my lord. I can be, no doubt, I can be trialless et al. I'm not on that, my lord, at this stage, my lord.
What was your prayer in the petition? Let me go to the petition. What was your prayer?
Prayer number 3, my lord. Kindly see my prayer number 3. At page, my lord, kindly at page 43, Lord, and prayer number 4, my lord.
No, there's no such prayer.
No. Prayer number 3, lordship, may kindly see page 43. Lordship got it? Declare that detainee is a child in conflict with law, having village so and so, entitled to protection under the Juvenile Justice Act and their juvenile justice rules. And my lord, prayer number 4, my lord, last operation part, to be illegal, unfair, unreasonable, arbitrary, discriminatory, unjust, with an issue, lacking any legal sanctity in the eye of law, apart from being biased, unconstitutional, and violative of the provision as provided and incorporated under the Act 2015 and the rules framed under the Rule 2006, vis-a-vis the law as has been held by the Honorable Apex Court.
In which case?
Therefore, my lord, to avoid the
Apex
complexity,
court in which
this
case?
court has, my
As
lord,
in the apex court in which case? Which case?
lordship,
Provision as provided and incorporated under Act 2015 and Rule 2016.
therefore, my lord, yes,
And by
lordship, may
the Honorable.
kindly see rule section 10, my lord. Section 10, my lord. Section 10, 12, rule 8, 9.
JJB.
You cannot put me in jail, my lord. That's what the rule says, mandate, my lord.
No. So that Third Learned Counsel, Mr. N.K. Murray, for the petitioner. X, for the petitioner, X within bracket name withheld, comma, as the petitioner has already been declared to be juvenile in conflict with law, by order dated 12/6/2026, passed by the Juvenile Justice Board of Wakha, Nagaland.
Twelve and 24/6, my lord.
This petition, the petitioner X had preferred this application under Article 226, read with Article 227 of the Constitution of India, read with Section 102 and 12 of the Juvenile Justice within bracket Care and Protection of Children bracket close Act 2015 within bracket the JJ Act for short bracket close, read with Section 528, 438, 442 and 187 of the B and SS 2023, with prayer for issuance of a writ of habeas corpus or any other such order. Full stop. The petitioner had earlier approached the next para. The petitioner had earlier approached the JJB, Juvenile Justice Board within bracket JJB for short bracket close, as well as the concerned jurisdictional court with the plea of juvenility, and this plea was and not this plea, and after the ossification test, it was opined that the petitioner was above 18 years. Full stop. The order dated 20/03/2025 reflects that the petitioner is above 18 years and the petitioner has agreed by this order and has prayed to declare this order as what? Unconstitutional.
My lord.
What
That's
is the
my
prayer?
lord. Page 43, my lord.
And to declare this order as null and void. Declare this order in connection with the Wakha PS case number 47/2024, corresponding to GR case number 72/2024 as null and void. So the petitioner has challenged the order of forwarding a juvenile for ossification test instead of considering the documents as per Section 94 within bracket 2 within bracket Roman 1 within bracket Roman 2 of the JJ Act. Full stop. By the order of this court 30/06/2025, the petitioner was granted bail. Full stop. Thereafter, this court passed an order dated 3/06/2026.
That may be incorporated, my lord. That may be incorporated for convenience, my lord.
Which is reflected here in below verbatim. You go to the order dated 3/06/2026. Paragraph 10. ठीक है ना? Paragraph 10. Thereafter, next paragraph, entire paragraph 10 within inverted commas and in italics. The inquiry হবে না? E. The inquiry was conducted by the Juvenile Justice Board, Wakha, Nagaland, and the report was forwarded to this court. After verifying the documents, the JJB held that including the birth certificate. After verifying the documents, including the birth certificate, the JJB held that including the birth certificate and the birth register book, the JJB held that the petitioner X, the date of birth of the that the name of the petitioner X was found to be registered on 6/2/2012, bearing registration number 6/2012. So it was also held by the board that the petitioner was below 18 years on the date of the at the time of the commission of offense, i.e. 16/12/2024. Heard learned PP Mr. KV Angami. Full stop. What was your submission?
This will be remanded back to GA board in terms of proceed. In terms of say, if you know the GA Act.
Who has submitted that after the receipt of the report dated 12/6/2026 from the JJB Wakha Nagaland, it is apparent that this matter has become infructuous. It is submitted that the case may be remanded back to the Juvenile Justice Board, Wakha Nagaland, and the matter may be decided, and the matter may be proceeded in terms of section 15 of section 15 of the JJ Act. Okay. Paragraph 15. Paragraph 15 and 16. Paragraph 15, 16 and 17. Okay.
That stage is over, my lord.
Huh?
That stage is over, my lord.
Sorry?
That stage is already over, my lord. With due respect, my lord.
Section 15.
Section 15 stage is over with due respect, my lord.
Let me check.
Now the accused is my lord, major, my lord.
No, but he'll be tried according to the procedure only. Section 15 of the JJ Act. The learned PP has also relied on the decision of the Supreme Court in Shilpa Mittal versus State of NCT of Delhi and another, reported in 2020 brackets 2 SCC 787, wherein it has been held that paragraph 15, 16, 17. It is next paragraph. It is further submitted by the learned PP that the juvenile was found to be above 16, that the present petitioner was found to be above 16 years and below 18 years of age. We have given a thoughtful consideration to the submissions at the bar. A perusal of the report dated perusal of the report of the JJB Wakha Nagaland dated 12/6/2026 clearly reveals that the petitioner is declared to be a juvenile in conflict with law and his age was found to be for entire inquiry proceeding has also been forwarded along with the report, which has been carefully scrutinized by this court. It is true that as the petitioner was below 18 years of age at the time of the incident, this present petition has become infructuous. Thereby, the petitioner is to appear before the Juvenile Justice Board, Wakha Nagaland, and the board may try the proceeding and in accordance with law.
Yes, yes, my lord, in accordance with law. Otherwise, my lord,
We will tweak the order a little bit here and there.
my lord, just one thing, my lord. My lord, this is a recent judgment, my lord. This is criminal appeal 3299 of 2026, my lord. This order has been circulated, my lord, Honorable Justice Patiwala and Ujjal Bhuyan, my lord. This order has been circulated entire state, my lord.
Which paragraph you want to refer?
My lord, this court has, my lord, says, my lord, regarding, my lord, what my learned PP has submitting, my lord. My lord, that preliminary assessments, my lord, that has to be, my lord, conducted at the initial stage when, my lord, ascertaining the age, my lord. Now, my lord, case is
It's
already.
okay. I have passed an order to decide the case in accordance with law.
Yes, yes,
I'll
that's
quote-
what I, my
I'll
lord.
quote your judgment also. Which is the judgment? Please refer.
My lord, I will supply, my lord, my learned friend is there, my lord. I will supply, my lord.
Which
quote, my lord.
paragraph? Which paragraph?
My lord, this, my lord, I will mark it, my lord.
You will send it through email.
Yes, yes, my lord. Yes,
Okay,
my lord.
then before conclusion,
My lord, this because of the fact, my lord, this judgment has been circulated to, my lord, entire High Court, my lord.
Before the PP submission, hard learned additional PP, before that submission, you include that, you just note it down, that the learned counsel, before conclusion of his argument, of the defense, of the petitioner's argument, the learned counsel for the petitioner has relied on the decision of the Supreme Court in so and so, wherein it has been held as. Then you write hard PP.
As well as the constitutional judgment, I will bless, my lord, regarding the
All
author,
right.
my lord. And
In
my lord,
terms
one
of-
kindly just small thing, my lord, because this process, my lord, it's, my lord, it will affect the entire, my lord, system, my lord. In days to come, my lord. That's what, my lord, I'm suggesting one thing, my lord. My lord, issue has to be streamlined. The court below, my lord, learned court below, with due respect, my lord. Because they are entirely floating the provisions
the court will deal with it accordance with law, in accordance with law.
Floating the provisions of law, my lord.
Will not lay down
How-
ratio. We have two Supreme Court judgments, so the court will deal in accordance with law. If it is
Yes,
not dealt with in accordance with law, we always have.
Yes, my lord.
You
Yes, my
always-
lord. I
you
agree, my lord.
always can resort
And my
to
lord, at least my
appeal
at least my detention may be to be, my lord, at least
We'll
illegal,
mention
my
it.
lord.
We'll mention
At
it.
least my detention, my lord. Because all along, my lord, I'm my lord, lodged in jail, my lord. So once I'm held to be juvenile, my lord, ultimately it will both side of the same coins, my lord. It will follow that I'm illegally detained, my lord. That's why, my lord, that
You are
observation may be made.
apprehending that you'll be tried as an adult.
No, I'm not saying that, my lord. At least that observation may be made, my lord. That my violation is to be illegal, my lord.
You are already on bail. It will be dealt in
No, no.
accordance with law. It will be decided by the court, and if not decided, if not required, the court won't decide. The court will try
lord,
you
I'm
as
not-
a minor below 16 years.
My lord, this court has absolute power to declare illegal or unillegal,
Nowadays,
my lord.
in all the courts, they pass orders. They always decide whether the person has to be, and they hold an inquiry. They decide. They pass speaking orders whether this person has to be tried as an adult or not.
No, I'm not saying that, my lord.
Don't contemplate
I'm not saying
anything.
that. My lord, with your respect, all I'm saying is that, my lord,
Don't speculate anything.
the provision does not mandate the juvenile justice court to send me in jail, my lord. Therefore, all I'm saying that once the juvenile justice court, as per the direction of this court, conducted an inquiry, otherwise, my lord, and held to be juvenile, my lord, my detention is illegal, my lord. That's what I'm saying. Otherwise, as lordship may speak, if this court has not interfered, what will be the, my lord, issue today, my lord? What will be the issue today if this court does not interfere with my writ petition at the first instance, my lord? If this court does not enlarge me on bail, what will be the issue, my
You're
lord?
on bail, no? You're on bail?
No, but this court, my lord, this court had kind enough to enlarge me on bail, my lord.
Now why
That's
you're
what I'm
talking
saying,
about
my lord.
bail?
No, I'm not saying that, my lord. Since petitioner is on bail, my lord, observation may be made that as per this direction of this honorable court, petitioner is already on bail, but in the facts and circumstances of the case, since petitioner already declared to be juvenile, his detention is declared to be illegal, my lord.
This
And
what?
I'm not pretending, my lord,
What is declared to be illegal?
this detention, my lord.
Okay.
Detention payload, my lord.
It's
I'm not saying
submission,
anything, my
you
lord.
write earlier in submission that to declare the detention of the petitioner to be illegal. In that submission only, right? Okay. All right.
I'm sorry, my lord. I'm giving trouble, my lord, because of the broader
No, no
aspect, my
trouble
lord.
at all. No trouble.
All right, my lord. I am obliged, my lord.
Yes, yes.
Sorry?
Copy of the report.
I want the judgment. Or report, yes, yes, report, your report, yes. Yes, yes, this is a copy of the report.
Give him back, give him back.
Don't give the
I'm
original
supplying, my
report. Original report, don't give the original report. Huh? I've sent one report. I don't know whether it's original or the copy. Huh? Copy?
This copy may-
Okay. Original is with me. All right. In terms of the above observation, this read petition stands disposed of.
I'm obliged, my lord. I'm obliged. Otherwise, my lord, I know, my lord, it's a, my lord, involving, my lord, NDPS. I understand at least to that aspect. But considering the fact, my lord, this, my lord, on one hand, my lord, if you view in different angle, my lord, the aspects is, my lord, quite rampant. That's what I'm, my lord, all I'm with humbles, just making as, my lord, submission to that effect. I'm deeply obliged, whatever.
You have been
order, my
heard
lord.
and everything is recorded. Each and every
Yes.
sentence is recorded.
I'm deeply obliged, my lord.
Over? Oh, break. Oh, okay. Okay. One part, thank you.
For others, item number 18.
Rest, we can actually work out when it comes to this, number 155. We just understand 65 one of case, then this is the all. So. the suspension of order was served to the equivalent. And the equivalent has challenged the suspension order. The constituency. And there. I've heard these things which are for the defense.
You see, he is convicted.
No.
Trial is proceeding. Okay.
There, for my first submission, I would like to take our ships to the CSS group. Very relationship.
Appreciate it.
Last page. This is the civil service classification protocol, and it will use 19.
Last page.
Is section 10 is subsection 7. Subsection 7.
Okay. Please read.
And order 7, an order of suspension made for a deed to have been made under subject 1 or 2 of this rule shall not be played after a period of 90 days unless it is extended after the review or a further period before the expiry.
Yes, it's true.
Coming to my submission, the submission order was issued on 7 to 25 by resolution administrative.
7 to 25.
Page 41.
Yes. Then it was not extended.
No, but here, there's two issues, whether the suspension order is 7 to 25 was reviewed or extended within 90 days from now, after the inform of this release. And number 2 is whether the memorandum of charges was issued by the authority was served within 90 days after being informed of his release from date. What should development was that the special court of Sorboka has released the appellant on default
Default bail.
on 21/5/2025. Subsequently, the appellant has submitted a representation intimating the authority on 2nd June 2025. I have made to my chart. And counting from the day of 2nd June 2025, the 90 days was expired on 31st August 2025. And after that, Lordships, no, between that stipulated time.
It was not extended.
No memorandum of charges was served. And the appellant has come before this honorable court challenging the suspension order on 6/11/2025. Lordship and then whatever was that only after the filing of the petition, only after the state respondent had constituted the review committee based on 2/12/2025. And it's to see at page 64.
Page 64. Okay, review committee was constructed.
Yes.
Constituted.
Yes. 2nd December 2025. Which is after the expiry of 90 days. And during the pendency of the petition, this committee was set up, constituted. The review committee was constituted. And on 16/12/2025, there is the minutes of the substation review committee worksheets. The review committee recommended for extension of the submission order worksheets. There is that page 66. The within minutes.
Worships, on 20th January 2026, the respondent number 3 has reviewed the suspension order. We only disturbed is 20th January 2026, which is after a lapse of 233 days, counting from the date of intimation to the respondent authority. Yes, Doctor. And then amendment of charges was issued on 10/3/2026. It is after a lapse of 252 days from the date of intimating to the authority. That is second June.
After how many days?
282 days. So all these things have been after filing the petition.
After a
Yes,
petition.
when the pendency of the petition, all this thing was done by the state respondents, which is after a lapse of 90 days. So, first it's here the petition appellant is aggrieved by the order passed by the federal single judge, whereby to the ground that the memorandum of parties have been served to the appellant.
Yes.
Whereas the memorandum of parties was served only on 10/3/2026, which is not within this stipulated final 20 days. So, worships here, the appellant is aggrieved by this.
He is Chowkidar in which department?
School education.
He was, okay.
Yes.
Education department has been made a party.
Yes.
We have education department.
Respondent number 3.
You have a respond number 3.
So, worships, the petitioner was brought to great suffer without any review or extension or no purpose was served with this stipulated time, next 90 days. So, worships, here the appellant is selling the judgment and order. So, my prayer is that the worship this honorable court will be refused enough to set aside the single judge the order dated 2024/3/2026 and allow them allow the issue.
Okay, let's hear.
No.
Huh? Oh, hold on.
Mr. Maho, how the single judge dealt with the issue? You raised these issues before single judge also. So how it was dealt with by learned single judge? What reasoning was given for rejecting your prayer? You take us to that reasoning of single judge.
Page 17, page 17, 12. For 511. If I may,
Yes.
511, is therefore.
Page 70.
17. of my-
Okay.
No, what was the reasoning in Ajay Kumar Chaudhary's case? What was held in Ajay Kumar's?
Relying on the legal versions.
What it says? Though it may go against you, you may tell us.
I also use the solutions, same solutions. Now, looking 7 CC, page 291.
Yes, what it says.
Here is in just relying on the judgment perhaps we need to. But this judgment is different because in my case is being suspicion. Whereas in this case, the effect is different and then time to time review has been done in this case. But in my case, no review has been done. Yes, then relying on this judgment, stating that the memorandum of charges was served to me. The observation of this single judge is
That was Ajay Chaudhary's case was proper suspension after show cause and after inquiry. So this is deemed suspension, immediately suspended after he was arrested. Okay.
There is para 21.
Paragraph 21. Yes. Yes, yes.
We therefore direct that the currency of substitution orders should not extend beyond 2 months. If within this period, a minimum of charges is not served on the delinquent officer at large. If the minimum of charges is served, the reason order must be passed for the extension of the suspension. As in the case in hand, the government is free to consider a person concerned with the department meaning of this office within or outside the state, so as to save any local or personal object that he may have and which he may misuse for obstructing the investigation against him. The government may also prohibit him from contacting the person or handling reports and against the stage of his having to prepare his defense. We think this will adequately safeguard a universally recognized principle of human dignity and the right to a speedy trial and shall also preserve the interest of the government in prosecution. We recognize that the previous constitution benches have been reluctant to require proceedings on the ground of delay and to set time limits to their duration. However, the imposition of the limit on the period of suspension has not been discussed in prior case law and would not be contrary to the interest of justice. Furthermore, the directions of the Central Vigilance Commission that heading the criminal investigating department of proceedings are to be felt in advance stands preceded in view of precedent developed by us. This relying on this principle, the civil judge has dismissed the division. However, now here this part one is very clear for ships. There should be within 90 days. However, in my case, this case is different from my case. The case of the case is different. I don't know that in 90 days, my extension should be reviewed. Basically, relying on the same rationale, which the president led to this work already closed. And I have also submitted this of edition 2021 for JLP 682.
Oh, yes, yes. I have read this case. We can read it, yes. Which paragraph?
For the aforesaid reasons, we see no bearing in the present view. We reiterated the principle laid down in Article 2 March of the League Supra, will be even in the case of suspension and accordingly, with no review of the suspension has been made within 90 days. Such a suspension and its continuation will be decided and will be liable to be interfered with. Paragraph 22. In the present case, since review was not within 90 days, but after 145 days, the continuous suspension of the requisitioner respondent heading cannot be sustained as held by the balance new judge. The other question is 2019 15 JLD.
Kara,
Para 16 and 17. Para 15 and 17. Yes. Para 15, 16 and 17. Yes.
yes, please.
We have to consciously apply our mind to the query raised by the single judge. Though the case of Ajay Kumar Chaudhary is a case where suspension order was issued pending withdrawal of disciplinary proceedings and not a case of suspension. The observation made by the Honorable Supreme Court in Para 20, whereby the vulnerability of section 162 was from CRPC 1976 has been probably. We are persuaded to follow that the principles laid down in the same case cannot be restricted to an order of suspension, which should not be on contemplative of level of disciplinary proceedings and not for the suspension. In our view, the issue should be seen from the perspective of the consequence and the effect of suspension, which is to say in both the cases. We also feel that no prejudice whatsoever could be caused to the department by such interpretation, inasmuch as no plaintiff order of revocation of suspension is passed, and it is left to the department to make periodic review within a period of 3 months and decide as to whether such suspension is required to be extended or not by assigning reasons, whether such reasons are justified and government can be the subject matter of a separate challenge. In view of the appropriate discussions, we answer the reference by holding that the principles laid down in the case of Ajay Kumar Chaudhary would also be applicable in case of the suspension under section 6 clause 2 of the 1964 rules, para 16. Further, in the same case, please see that order of suspension is also an account of pending double of disciplinary proceedings, in which case periodic review within 3 months is otherwise held to be mandatory. Since we have already answered the reference holding that periodic review in the case of the suspension is mandatory, the referral of remanding the matter to the learned single judge would be a meaningless exercise as agreed by the parties. While answering the reference as above, we are of the opinion that the case of the preference of the impugned order dated 2019 is clear out. According to the order suspension, such and such issued by the Division Forest Officer of the Wildlife Division is hereby set aside in clause. Option. The other attachment is 2003 voluntary GLT. Sorry, 2023 GLT 718. This is the same justice his spouse has relieved the petitioner in a similar case. Para 21 and 22. Para 21 and 22. Para 21. Now coming to the same case, it would be seen that it was only on 7/12/2022 that the petitioner was released on bail. There is not a single mention in the petition to the fact that as to whether the petitioner had informed the appointing authority that he has been released on bail. Be that as it may, this court having issued notice on 1/2/2023 would be that the respondent authorities have noticed that the petitioner has been released on bail on 7/12/2022. Taking into account the state date of issuance of notice, that is from 1/2/2023, the responding authorities have time to 34/2023, that is 3 months, in that appropriate states in terms with the observation made in paragraph number 20, herein above, as well as paragraph 21 of the judgment in the case of Ajay Kumar Chaudhary Supra. It is further observed that the above observation shall not preclude the appointing authority to reinstate the petitioner to his office in the pending facts.
if during this period of the 34th administration that appointing authority deems it proper to reinstate the petitioner, paragraph 22, it's made clear that if within 34th administration, the amendment of charge sheet is not served upon the petitioner, the further continuance of suspension by the immediate order dated 15/10/2022 would be in violation of the order passed by this report in the case of agent authorized. Consequently, the concerned appointing authority would have to reinstate the petitioner for 4 years. Here, the petitioner have not informed the authority of this release, but the filing of the regulation counting from that date, 3 months has been lapsed. But no extension, no practice was served. Based on that, report, the one report has observed, and then the chief was given to the petitioner. So in my case, the authority, the authority that is responding to administrative level extended my suspension order, no amendment of charges was served to me within the stipulated period, it is 90 days. Only after filing of regulation, the respondent authorities, after all the dependency of my regulation, everything has been done. The committee has been set up, and then the review, my suspension order was reviewed, and the amendment of charges was served to me. So which is not within the stipulated time, it's 90 days. So I challenged before the civil judge the suspension order over my petition was dismissed. So, Lordship, based on this judgment, I pray before this honorable court, request and set aside the order dated in 14/2026.
It's relying into this situation. And the ownership is not informative, the judgment must have been the citation speech, my limit, and then is for your question. The face of it, does not case the environmental charges which only plan. Whereas in this case, the environmental charges should just like.
No. One query. Is there any requirement to issue memorandum of charges within 90 days? No, suppose within 90 days of date of suspension, deemed suspension, memorandum of charges were not issued, and neither the suspension has been reviewed, whether that suspension will stand. Then suppose in a case after suspension of the incumbent, lapse of 90 days, memorandum of charges has not been issued. It is issued after.
Yes. That is also, in fact, the initial suspension orders and the issuance of the of charges is after the lapse of 3 years of worship. If you worship may anything will this way. This is exactly what the lines of that statement is. Yes, it's pretty much.
Yes, yes.
Therefore, direct the currency of a suspension public should not stand beyond 3 months. Within this period, the memorandum of charges charging is not served under the legal officer in place. If the memorandum of charging is served, there is an order must be passed for the extension of the suspension. As in the case in hand, the law ministry to transfer a person concerned to any department in any, I will speak this and. As in the case in hand, the government is free to transfer the person concerned to any department in any of its office within or outside the state, so as to trigger any local or personal contact that he may have and which he may misuse or obstructing the investigation against him. The government may also prohibit him from contacting any person or handling records and documents till the stage of his having prepared his defense. We think this will adequately safeguard the universally recognized principle of human dignity and the right to a speedy trial and shall also preserve the interest of the government in the prosecution. We recognize that the previous constitutional benches have been reluctant to pass proceedings on the grounds of delay and to set limits of their duration. However, the imposition of a limit on the period of suspension has not been discussed in prior case law and would not be contrary to interest of justice. Furthermore, the direction of the Central Vigilance Commission that pending the criminal investigation department proceedings are to be held in the instance superseded in view of the stand adopted by us. So far as the facts, this is important leadership. So far as the facts of the present case are concerned, the appellant has now been served with the charge sheet, just same as in this case. Has been served with the charge sheet, and therefore these directions may not be relevant to him any longer. However, if the appellant is so advised, he may challenge his continued suspension in any manner known to law, and this action of the respondents will be subject to judicial review. Your Lordship, even in this case, Your Lordship, the judgment in three. The three was similar levels of this Supreme Court is not the Lordship.
No, I. No, I just want to understand one thing to both of you. The law says that from the date of suspension, if within 90 days charge sheet is not submitted, charges are not communicated, then and unless there is a review for extension of the period of suspension, the suspension will lapse. In the instant case, within 90 days, there was no review of the suspension. Neither charges were communicated. Even if we take that communication, there was no communication of. Now, your submission is that since charges are submitted, communicated, the lapse of 90 days, that principle will not be applicable.
So, in Ajay case, in fact, the initial suspension.
Later on, reviewed.
After a lapse of 3 years, here is a matter of 3 months.
So what is the principle laid down in Ajay Kumar's case? What was the ratio? What was the principle that if you submit charges after not 90 days, there is no duration. If you submit charge sheet even after 1 year, 2 years, the earlier stipulation of 90 days will not be applicable. Is that the principle?
So you see, what we understand is that according to Ajay Kumar Chaudhary's, earlier it was not reviewed. That is not correct. It ought to have been reviewed within 90 days. It was not reviewed. Now they have reviewed. And so now their memorandum of charges have also been framed. So according to Ajay Kumar Chaudhary's case, now at present, you can assail this, but now this case is not barred. The suspension order, the reviewed order, the second part of the order, reviewed order is not barred. This is what we understand, what she's submitting, and this is the principle according to her. So he is asking what is the principle according to you?
The fact is different. With the pendency of requisition, Everything else, everything was done after pendency of the regulation. Till the filing of regulation, no review was done, no memorandum of charges was served during the pendency of regulation. As supposed worksheets, if this is accepted, even in the future, the department will do the same thing. During the pendency of the regulation, they will do after all these things, then the regulation will not get any relief. CSS will say, after 90 days expired,
There has to be a review.
and then if Kumar is making trouble of proceedings for chiefs, here things suspension. And in Ajay Kumar case, time to time review has been done, but in my case, there is no review.
No, there has been review. There has already been review.
Proceed, but within 90 days.
You see, same case. First time there was no review within 90 days, but in Ajay Kumar's case, and then thereafter they have reviewed the order after lapse of 90 days. So here also they have not reviewed within 90 days, and after lapse of 90 days they have reviewed.
But I call the government, yes.
In Brigham Holloway's case.
That during the period of 90 days, responsible, sir, then review was not done. If we not similar cases, our own budget request passed and you didn't reject.
No, they approached the single judge before they were served with memorandum of charges or before any review was made. They approached the single judge when within 90 days no review was made and neither suspension was revoked. Then after filing of the writ petition, you reviewed and used.
People was considered after doing the pendency of petition, people was considered and the review was recommended and on 20th January 2026. The respondent
No.
has
Let her submit. We want to understand the ratio in Ajay Kumar. Is it the ratio that you can serve the memorandum of charges as late? There is no time limit prescribed, and as soon as you serve the memorandum of charges, the earlier condition of reviewing the suspension 90 days goes.
The first part, it therefore died that the currency of the suspension order should not extend beyond 3 months. If within this period, the memorandum of charges is not served on the delinquent officer or employee.
But when we read para 22,
here. Once you come here, the charge sheet, within charge sheet, there's the company's file. The charge sheet has been filed, but here, charge sheet is not the issue, the review. Suspension, review of suspension.
No, what were the facts of Ajay Kumar's case?
আপনি কোন থেকে রেজিস্টার বিজনেস হিসাবে আপনি লিখে বলে আপনি তারপর রেজিস্টার
একজন মানুষ কখন সাসপেন্ড করে 90 দিন আপনি সাসপেনশনের রিভোকিং করবেন সাপোজ 6 মাস সাসপেনশন করবে and charge payment of the money. They in a building that right at the get suspension revoked. They can problem.
Rules of service rules of support as a home to assess central.
She's going very slow. যেহেতু চাষি এখানে আমি তো চাষি 2 বছর পিছন দেব
It was just is to cycle to society paragraph 22.
এখানে যে চৌধুরী ট্যাক্স paragraph 22 to ratio laid down paragraph 20.
21.
What are the facts of Ajay Chaudhary's case? You have not gone through it. Because Ajay Chaudhary has to be understood in context of facts of that case. Para 22, the observation made by Apex Court in para 22 of the is in context with the facts of that case. In para 21, general proposition of law has been laid down. In para 22, considering the peculiar facts of the case, court held that proposition of law which it formulated in the preceding paragraph is not applicable. So you must be aware of the facts of Ajay Chaudhary. So what were the peculiar facts? Yes.
Which paragraph?
Yes.
The Nagaland states suspension which was 39,011 has been extended and continued ever since. In November 2006, he was possessed as.
So in Ajay Chaudhary, there was extension of suspension, which is not there in the instant case. So whether that extension was made after every 3 months.
No. Not done in this case.
No, in Ajay Chaudhary's case, what happened? Read further.
November 2006, he was appointed as state defense state minister. During this period, we must discover that large portion of the land owned by the Union of India and held by the Director General of Defense State have not been evaded in order in the regular reports as defense lands. They have begun allegation that between 2000 and 2009, office knows where the third party started, namely such and such land, that approximately 4 acres of land were not defense lands, but were private lands in respect of which NOCs will be issued. These NOCs were accordingly issued by the appellant. Thereafter, in 3/4/2000, the appellant was transferred to such and such on the worldwide level, there is such and such. The appellant was asked to give this explanation for issuing the actually incorrect NOCs. In his reply, the appellant admitted his mistake, denying the need nullifies the issuing the NOC and included the issuance of the NOC to the laws prepared by the subordinate staff of the bureaus. The bureau of the ground that he received a sufficient order dated 13/9/2011. To reverse the issue of.
Just a moment. So you see, it was extended within a period of 3 months. First extension was within a period of 3 months. 39/11, 28/12/11.
Yes.
At the time review was extended. In my case.
It was, no, it was not extended. No, okay.
Based on this, even now, they record this, relief to petitioners in first cases. And lordships here.
Saturday.
Lordships here.
So it's okay.
Yes.
It's okay. This is the main point. Not required.
Miss Inaholi, you have anything to say? No, that is not the issue before us. Issue is whether if the suspension is not extended time to time after 90 days, and then charge sheet were served after a lapse of considerable period of time, whether the petitioner will get benefit of lapse of suspension order due to non-extension, non-review of the suspension order within 90 days. That is the issue. Or whether by merely so even your submission is even if no review is made after 90 days, once memorandum of charges is served, that requirement goes.
In other day, as you told this case, in this case, in this, after,
So,
after that,
so your submission is that government may choose to review at any time as per its own sweet will. Yes.
Page 54 of your counter affidavit. Page 54 of the reader page.
There's no activities that there is because the submitted a representation requesting the provision of suspension order and same was disposed by the department. The agent order was still in process. It may be mentioned here that the petitioner was created under also Act 2012, which involves moral tribunal and is prejudicial to public service, especially a government employee working in a school setup. As such, pending the criminal case review was necessitated. Accordingly, the department by later dated such and such, later number such and such, dated 3/7/2025, and reminder bearing number such and such, dated 11/11/25, wrote to the government for constituting a review committee. In the meanwhile, the department also received letter bearing number such and such, dated 28/11/2025, from the Office of the Superintendent of Police, or stating that after receiving a positive report from FSL against the accused petitioner, charge sheet under such and such has been sent to the court. But with regard to the paragraphs, that with regard to the statement made in paragraph 8 of the petition, the answering component states that by notification bearing under such and such, dated 2/12/2025, review committee was constituted for review of suspension order. By later bearing under such and such, dated 11/12/2025, the department requested the review committee to convene a meeting for review of suspension order. Accordingly, the department suspension committee meeting was held on 16/12/2025, and the committee recommended for continuance of suspension, subject to periodic review in view of the pendency of criminal proceedings involving grave charges under the POCSO Act 2012, as recommended by the review committee by order dated such and such. The department is extended the suspension of the petitioner until further order. And motion I may also that with regard to the statement made in paragraph 9 of the petition, answering the following does not have it, which is not right. And the following further states that as per Rule 10 sub Rule 7 proviso CCS restriction control and rules 1965. Review is not necessary in case of continuous detention if the law 7 continues to be under detention in the time of 90 days of suspension, and the 90 days period in such case will count from the date the government 7 detained in custody is released from detention, or the date on which the fact of his release from detention is intimated who is appointed also, whichever is later. Accordingly, on receipt of petitioner's representation dated 2/6/2025, intimating his release on mail, the respondents by paper dated 4/7/2025 dispose of the representation stating that the suspension order is being repeated in the department, hereby refuting the statement that the
So in this case, as per your own submission, from within 90 days from 2/6/2025, review ought to have been made. Because you received the intimation about his release on 2/6/2025.
So, which is from 2/6/2025, I've submitted a resolution to the certain authority, then I've been released from the.
Yes.
Jail. Yes, I was released on bail. I've been taken to the authority.
Yes.
And then 2/6/2025 has been less on the 31st, August 2025. And we are trying this, the repetition of 6/11/2025. And all
Okay,
these
okay, okay.
subsequent orders have been.
Okay.
only after the-
Yes, Ms. Sila.
Okay, between the. Yes, we like is a resolution setting up. The suspension for the. I think if I may be able to.
Yes. yes.
Thereby refuting the statement that the state responded did not take any steps to review or extend the suspension order. It may be pertinent to state that bail was granted to the petitioner for the delay in filing of the charge sheet by the police and does not in any way affect the seriousness of the allegation in criminal proceeding, nor reflect the employer's innocence. In fact, the proviso of Rule 6 of Nagaland Service Discipline Act will provide that mere release of bail is not a ground for vacating suspension when the criminal trial is pending for serious charges and grave offences and the charge involves moral tragedy. That the department further reiterates that the department is already reviewed and extended the petition suspension order. It may however be mentioned that the delay in issuing the review order of the suspension was occasioned due to delay in receiving the status positive report of the forensic science laboratory against the accused person petitioner from the office of the superintendent of police for Nagaland, which was necessary for informed administrative assessment that the interdepartmental procedures takes time, hence such procedures do not automatically invalidate the suspension of the petitioner, since the offence under the petitioner is charged with grave. This petition some delay, but the department was not idle initiative, taking steps.
The affidavit number was filed on 24/3/2026. And we have received, on that day, we have received the copy, this is the photo, and on the day itself, that matter was heard.
It was from the business.
And also, lordships here, the document itself states that everything has been done after the filing of the petition. So after a lapse of 90 days, suspension order was not reviewed. And moreover, this is the memorandum of charges was only on 10/3/2026. So after a lapse of 90 days.
Your name?
It will not be.
Hard Learned Counsel, Mr. W. And for the petitioner and Learned Government Advocate, Ms. Inaholi, for the state of Nagaland, for the respondent state. Reserved for judgment and order.
Right.
For orders, item number 23.
Pin this up. We have pin, huh? Pin code even. It was.
On last dimension, right, responding more and patient. The various like the things that we find are so long many times. And this is for the dimension of the time of the
100 days of delay.
As of today, my lord, we have responded before just trying to 4 times on 4 occasions.
The evidence, the pleadings are complete, no? Complete also, theatre check also. Let them appear. 100 days. If it's 1 day, then it's okay. 2 days, it's okay. Yes, we'll record it. Learned counsel, Mr. is present for the applicant. Full stop. The respondents are not represented today. Full stop. List this matter for hearing on the application positively without fail. Full stop. On absence of any of the parties, necessary orders may be passed. All right. List this matter for hearing. List on. We'll fix a date. Yeah. We'll fix a date or after 1 week. List after 2 weeks. Over, no?
DP matter over.
Single bench, I have 1 matter left. It was fixed by another bench.
For admission, item number 1.
May please, Your Lordship.
Yes, yes.
I'm sorry, my lord, it got listed on a division bench day. It was supposed to be listed tomorrow, I guess. And otherwise, it was fixed on 12th. That's why it got into this
It's
confusion.
okay.
My lord.
Doesn't matter.
My lord, on the last occasion also, the government council did not appear. Notice was issued. The government council has accepted notice. I guess he is there today. So they have not filed. They have not filed. I'll just give a brief background of the case, what exactly the case is about. It's
That's
a
not required, I think.
Okay, my lord. But
Not
no,
required.
my lord, yes.
I have been informed by the department that the instruction is done.
Let him obtain instructions.
My lord, only thing is that there on the last occasion, on the very first occasion when notice was issued, that was in the month of June, 25th of June. There's a issue regarding consideration of the interim issue. That is one higher education allowance which has been paid to the judicial officers. Now that has been also stopped. It is not the final prayer. Final prayer is different. It is with respect to increase of the risk allowance, increase of the higher education allowance. But there is an education allowance which was already paid to the judicial officers for upgradation of their LLM and other postgraduate degrees. But then government, after a promotion, has stopped to pay that amount also. Several judicial officers are affected by that. And in fact, for last 2 months, they have not even get the instruction. On the last occasion, there was no one present.
He's saying that it is under process. So he will just obtain instructions.
Okay, Malad, then Malad may give a short date. Let them have an instruction.
Not in.
And thereafter, Lordship, I have received a strong copy from the Petition Council on 1776. Thereafter, I have given to the department, to the biggest respondent, and I have been informed by the biggest respondent that instruction is under petition, and the Lordship, in course of time, Lordship, said he asked instruction. So I mean, how to start?
Everything is under process. Instruction is under preparation. So let him obtain the instructions.
My only problem is I am not able to hear my learned friend's voice properly. But
Yeah,
it's okay.
I cannot hear. I know there's some snag here.
My lord's voice is very clear, but then his voice I'm not getting.
I know. There's sort of snag here. There's an echo in the microphone, in the speaker.
Okay.
Heard learned counsel Mr. K. Chaudhary for the petitioners. And learned government advocate Mr. Sorry, V. Vijimomi for the respondent state. So it is submitted for the respondent state, no? It is submitted by the learned government advocate that he will obtain instructions shortly. Full stop. Thereby list this matter after 1 week. List this matter after 3 weeks. 3 weeks?
Yes, madam. My lord, can you give a date if it will be convenient?
One date, not on a DB day, okay? Not on Wednesday.
Can it be on
28 August?
28 August?
27th is 27th.
3rd September then.
3rd September? 3rd September? 3rd September. Both the cases, no?
Only one case.
Only one, okay, only one case. All right.
Pleasure.